Hello, everyone. Welcome to another lecture in forensic psychology. Today, we are going to be talking about interrogations and confessions associated with our course for the semester. When we think about the idea of interrogations and confessions, one of the major issues that we always have to consider is that whenever it is that an individual is apprehended and potentially being accused of a crime, it's very important for us to understand what the role of the interrogation and also of the confessions are going to be taking place within the criminal justice system. Because what we're trying to avoid here is to have an individual who is accepting culpability associated with a criminal act when in reality they may be innocent of the crime or they may have had a different role associated with the crime itself. So when we think about confessions, when we think about this particular aspect, physical evidence is very persuasive whenever it is that we have a criminal trial occurring or whenever it is that we have a testimony being given by an individual, but rather having a confession by an individual who's being questioned and who's suspected of that crime is going to carry a lot more weight in terms of their ability to actually be considered to be guilty of that particular crime. So we actually see that anywhere between 39 and 49% of suspects actually make full confessions whenever it is that they're actually interviewed by police officers, meaning that when we look at this idea associated with the interrogation procedures, interrogations are being very, very effective in being able to allow or get an individual to be able to confess to a crime. Now again here, hopefully what we're wanting to do is that we're wanting to have individuals confess to crimes that they actually are truly guilty of and not necessarily being persuaded or pressured into actually being or to creating a confession in that particular sense. Now, whenever it is that confessions are looked upon in comparison to physical evidence, definitely confessions are much more preferred than the actual physical evidence or even going to trial, because once a confession is actually being made, now the trial can be avoided. You don't really now have to gather any of the physical evidence, or you have to gather it at a more decreased rate because the individual has already provided the confession. And ultimately, confessions nearly always guarantee that a conviction is actually going to occur for that individuals. And we also see that juries are much more likely to be persuaded to convict an individual who has already confessed to the crime, even though some of the physical evidence may not be present or may not be available for them to be able to make a decision. But if the individual confesses to the crime, they're much more likely to actually be able to confess and to be deemed guilty of that crime. Now, Casson and Newman back in 1997 ultimately created the idea associated with looking at how much confessions actually relate to the idea of conviction rates. So one of the things that they did is they presented 4 types of criminal trials. They presented theft, assault, rape, and murder trials, and each had very weak circumstantial evidence in terms of the physical evidence that was gathered, but they either included a confession, an eyewitness identification, or even a character witness testimony. And in 73% of the convictions that were actually given to confessions were deemed appropriate because the individual had confessed to the crime, not necessarily because they actually had the evidence to suggest that they actually did commit the crime, but just because they confessed to the crime, that was good enough for the jury to be able to say, yes, we are going to convict you in 73% of the trials that were given at that time by these researchers. Now, again, like one of the issues that I was trying to address here was the issue associated with coerced confessions, or the pressure associated with a confession, that we always want to try to reduce that likelihood. And what we see is that whenever it is that a confession is actually used in a trial, that we say the individual who is on trial has already confessed to the crime, even if there is coercion that is presented with the confession, very rarely are judges dismissing dismissing those confessions, even if they find that there is some aspect associated with coercion. And a lot of that relates to the idea that the individual who is confessing to the crime is voluntarily confessing to the crime, and they are in control of their own ability to either confess or not confess. And if they are truly not guilty, they shouldn't confess. And no matter what coercion techniques you use, the individual should not confess to the crime at that point. So ultimately, judges view it in that particular fashion, and juries will also view it in that particular fashion because they believe that the extent to which the confession is actually being taken is voluntary, not necessarily because they're being coerced to being able to confess to that crime. Kaysen and Sekul back in 1997 also looked at this idea associated with coercion and how coercion ultimately affects an individual in terms of confessing to a crime. And one of the things that they looked at was how jurors responded to these potential confessions, and still looking at the conviction rates associated with the confessions, even though there may be low, high, or even no coercion being presented in those particular cases. So what Kaysen and Sekul actually did was they had mock jurors read transcripts involving no confession, a low pressure confession, or a high pressure confession situation. And the jurors recognized that even in the high pressure confession situation, even though it was coerced, they still provided a 50% conviction rate, even though they deemed it that there was actual coercion that did take place in terms of the confession that was given by the individual in that transcript. So ultimately, looking at the idea of coercion, we still see that there is high conviction rates in terms of an individual, even though we may know that we should not coerce an individual to confess to a specific crime because there is no physical evidence behind it, or because they are saying that they are not guilty, but rather when there is coercion present, an individual still is more likely to be accused of the crime and even convicted of the crime, even when they know that coercion has taken place. Now, we definitely see that with interrogation techniques, sometimes the interrogation techniques that are used may potentially provide some of those coercion methods or measures that are sometimes observed in some of those particular situations. And one of the things that we try to do with interrogation techniques is definitely try to have the individual understand that it's still on them to be able to confess to the crime or not, but yet we want to get to the information as best as we can. So even in some particular uses of interrogation techniques, there may be some pressures that are placed upon the person, but you never want to place sufficient pressure that it's going to look like if it's coercion and that they never have any out if they do not confess for the crime itself. So ultimately, Inabu and their colleagues back in 2004 created what are called the criminal interrogation and confession techniques, where they recommend how it is that we should have interrogation rooms being set up and how interrogation techniques should really be created for these particular types of situations of interrogations. Now, aside from just giving recommendations on how to set up interrogation rooms, they ultimately also provided how interrogators are instructed to carefully orchestrate the procedures that will eventually overwhelm the reluctant suspect and get them to talk. So again, here putting the right amount of pressure in the right places at the right times in terms of how to get this individual to actually talk about the specific events or lead them down the path that gets them to talking about that specific event, and making sure that it does match up with some of the physical evidence that is actually there. Now, we also want to be able to see that how these techniques are actually being able to use, that they're ultimately going to be there to emphasize or even exaggerate and strengthen the evidence that's against them in those particular cases. So as I was mentioning, that part of what we want with the confession itself, or with the responses that the individual is giving during the interrogation, is that they should match up with the physical evidence that we have. If they don't match up with the physical evidence that we have, then here we ultimately are identifying that the individual may not be responsible for the crime, or they may be lying in another particular aspect, and we still might want to ask other surrounding questions that may lead us to being able to have evidence that would be against the individual in that particular case. Now, we also want the individual to be able to write or sign a confession once it is that they've actually agreed to confessing to these particular crimes. If the individual does not write or sign the confession that is written, it's very hard later on to be able to say that the individual was willingly knowing what it was that they were saying and that they were confessing to the crime. They may say that they were being coerced or that they were being misled, and they didn't even know that they were acknowledging that they were committing those criminal acts at that time. Now, we definitely do see that there are different interrogation techniques or even steps in terms of how to actually use interrogation techniques. And Reed actually provides a 9 technique step model that ultimately uses very modern techniques that are very much psychological in their nature to being able to gather information associated with what the individual is presenting in terms of their responses. And a lot of the influence that really does come from the 9 step technique is really in terms of the loss of control by the individual. So the individual losing control over their own responses and thus disclosing a lot more information. You may want to put the individual in social isolation, so keeping them apart from other individuals and making them feel that there is no escape, so they have to respond in these particular fashions or give the truthful responses to be able to escape that isolation. Also, the certainty of guilt, and also having expository scenarios where ultimately you talk about what it is that may potentially happen to these individuals if they do not confess to the crime, in full knowing that they are actually guilty in those particular instances. Now, we also see that whenever it is that interrogations actually occur, that Miranda rights are going to play a huge role in terms of how it is that we gather information. With Miranda rights, the individual does have the right to remain silent. Anything that can be used against you in the court of law that you say, you also have the right to the presence of an attorney to assist you prior to questioning or to be with you during questioning if you so desire. And you cannot afford an attorney. The right to an attorney can be appointed to you prior to questioning. So ultimately here, we always want the individual to know what their specific rights are, and also for them to give verbal confirmation or written confirmation that they understand these particular rights. If they don't, that's where problems start arising whenever interrogations are taking place or confessions are giving, even though they have not agreed upon their Miranda rights and saying that they do definitely understand them. And we also have to let them know that the responses that they are giving, they are voluntary and that they're not being coerced or they're not being placed upon undue pressure to be able to respond in those specific fashions. Now, confessions that violate the Miranda rights may be used to impeach a defendant in certain instances, but the confessions by a defendant who don't fully understand the warnings may still be admissible in some particular instances if it's assumed that the individual may be lying, that they didn't understand their Miranda rights or anything else associated with that. But sometimes because of the individual's age, their intellectual disability, their psychological instability may sometimes hinder them from being able to understand their Miranda rights in those particular instances. To stop an interrogation from occurring, a request for a lawyer must be unequivocal. Maybe I should get a lawyer is not something that is sufficient for an individual to actually receive a lawyer in that particular case, but they have to say, I will not answer any more questions until my lawyer is present because I do not feel comfortable answering these questions without my attorney being present. Miranda rights do not apply unless the suspect is in custody of the police. So when you are getting questioned on the roadside of a motorist, for instance, being stopped by for a drunk driving is non-custodial, even though the motorist is not free to go, warnings are not necessarily required in those particular instances. So Miranda rights are not necessarily having to be read at that particular time if there is a potential idea that the individual may be intoxicated in those particular instances that we may have. And also, Miranda does not apply unless the defendant is being interrogated. So voluntary confessions are not protected under the Miranda rights as well. So here, the individual, if they give the information voluntarily, even though the Miranda rights have not been discussed with them, we may still have that being admissible in a court setting. Now, we also see that the police are not required to tell the defendant anything more than what is contained in the Miranda warnings or have any further explanations, because again, here you expect that the individual understands the basic properties associated with the Miranda warnings or the Miranda right in this particular instance. Now, the police, if the police potentially, for instance, mislead an individual about evidence in order to get them to confess, these are clear violations associated with the Miranda rights. And we definitely want to try to avoid that as best as possible. And like I mentioned, Miranda warnings are not required in situations in which public safety might be endangered by giving warnings in those particular cases. So here, if we see an individual who's running around with a gun, and you're trying to stop that individual, you don't have to stop and reading their Miranda rights out loud and then trying to arrest them in that particular instance. Here, the public safety is much more important than reading their rights in that particular instance. Now, we do also find that only about 20% of suspects in police custody actually choose to exercise their Miranda rights by not answering questions or having an attorney being present in those particular cases. But 80% of suspects submit generally to full interrogations without having an attorney being present. And sometimes this occurs because the person doesn't actually understand what their rights are, even though they've already been told that they can have an attorney being present, or because sometimes the individual may assume that they don't need anybody else being present there, and by having an individual who is a lawyer being present might actually get them to look as if they are guilty and not guilty in these particular cases. So having a lawyer being present may make the individual feel that they are giving an indication that they are guilty by wanting to remain silent and not cooperating with the police in those specific instances, or cooperating with the police in those specific instances. Now, we definitely see that false confessions do sometimes take place, and these take place for many reasons. Some of the reasons may be because, again, they are subjected to a very powerful situational force that makes them do things that they do not want to do in those particular instances, or that are being very hurtful to them. So take, for instance, a torture situation where an individual is receiving some type of torture. The individual might confess to a crime, or might confess to a behavior that occurred, just so that way they can get the torture to stop. And again, depending on the individual, depending if they're very young, if they're inexperienced, if they're very naive, if they're easily dominated or they're influenced by drugs at that point, they may be much more likely to confess to a crime even though they are not guilty. And again, sometimes they are just so terrified of the particular situation that they're afraid that of what's going to happen. And sometimes they're also given the idea that, well, if you confess to the crime, it's going to be much less difficult, or it's going to be less hurtful for you if you confess to the crime right now than if you don't confess to the crime. So here we're trying to be nice by giving you the opportunity to confess and trying to help you out in this particular situations. Now, we definitely want to, again, try to avoid of false confessions, and there are interrogation suggestibility questionnaires that are actually out there that are actually used to be able to identify if individuals are much more susceptible to false confessions than other individuals as well. Now, we also want to try to have videotape confessions as much as possible, because definitely by having a videotape confession, it's going to be much more likely that the individual who's interrogating the person who's in custody is definitely going to follow correct procedures, because they know that they're going to be evaluated or looked upon later on. And also, it does provide real evidence in the terms of a video that if a confession is given, it's going to be admissible, especially if the individual is given the option to confessing or not confessing, and it is a voluntary confession at that point. Or that if something may have happened during the interrogation technique, that the individual who's in custody says that they were treated inappropriately or mistreated in that particular situation, it's going to be much more helpful to have that videotaping evidence. But in reality, only about a third of large police departments actually use videotaping interrogations. So we see that it's still not that frequently used in certain situations. Judges and jurors can also view those confessions later on in court, and that becomes a very, very useful technique. And we also find that both technical and psychological problems with videotaping of confessions sometimes occur, because if an individual knows that they're being videotaped, they may respond differently than if they were unaware of them being videotaped. But if you are going to videotape them, you definitely do want to get their consent that they are getting videotaped, and let them know that you are videotaping in that specific instance. Now, there are some possible technical problems that may exist associated with videotaping of certain interrogations. The sound quality may be poor. The picture quality may also be poor. The lighting, the limited viewing of what is actually occurring in the room itself. An individual may be blocked off or hidden away that may be providing some type of coercion to the individual who is being interrogated at that time, who does not come out in the video, so that may be problematic in certain situations. So there are definitely technical difficulties that may exist. Sometimes cameras may be turned off or started only midway through an interrogation because they were forgotten to get started. It's happened to all of us that we think that we're recording and we weren't recording in that specific situation. So here, those are definitely some other problems that may occur. Questionings that may sometimes occur at home or in other locations, like at the job. Of the individual who is potentially being interrogated, and they may not have full interrogation equipment at that time and have video taping equipment available that may be also problematic. Now, what are some of the psychological problems that may potentially exist with the videotaping of an interrogation? Jurors may, for instance, interpret the confession very differently depending on how they are presented in the videotape itself. The video recap itself contains the clearest admission of guilt that the police were able to obtain because, again, it should be able to identify if the individual is doing this on a voluntary basis or not. The admission of guilt ultimately takes place after a very long process of an interrogation, and the defense's exhaustion, again, that fatigue aspect, them being tired and terrified of the situation, may lead to him or her looking as if they were very cold or being a very remorseless criminal that ultimately may result in a greater sentence and a higher likelihood of conviction in those particular instances. And also, videotapes sometimes show that only the suspect created the impression that the interrogation was not coerced in those particular instances, but sometimes coercion may exist in other forms that were not captured by the videotape process. All right, that wraps up our discussion associated with interrogations and confessions. Please make sure to complete any additional information that is covered on Blackboard, and I hope that you all enjoyed this week's lecture.